want to welcome you to the Washington Legal Foundation and our annual briefing on the Supreme Court at the end of its term. This is the 26th year that the foundation has been doing this. It's the longest running program of this kind, I believe, in Washington and offered nationally now because of our webcasting capabilities. I'm Glenn Lamby, Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the foundation, we are a nonprofit public interest law and policy center which advocates on behalf of free enterprise principles. We are very active in the federal courts, especially the Supreme Court. This term, our moderator will tell you a little bit more about that. We had originally scheduled to have our Legal Policy Advisory Board Chairman, Dick Thornburg, former Attorney General, to be our moderator today. Mr. Thornburg unfortunately couldn't be with us, so our General Counsel, Mark Chenoweth, is going to be moderating the proceedings, and I will turn it over to Mark.
Thank you, Glenn. We're delighted to have three appellate practitioners with us today. We will lead off with Dan Himmelfarb, who's a partner in the Washington, D.C. office of Mayor Brown. Dan is not only a member of the firm's Supreme Court appellate practice and co-leader of its Washington, D.C. litigation practice, but he is also former U.S. Attorney in the Southern District, Assistant U.S. Attorney, rather, in the Southern District of New York for 5 years, and served as 5 years as an assistant to the U.S. Solicitor General as well. He has argued 40 cases in 9 different appellate courts, including 12 in the United States Supreme Court. Following Dan, we'll have Mark Davies, who's a partner in the Washington, D.C. office of the Orrick, Herrington Sutcliffe firm, where he's a member of the Supreme Court and appellate practice group. Mark is a former member of the appellate staff at the Civil Division of the U.S. Department of Justice. And last but not least, we'll have Jeff Rosen, who is a partner in the Washington, D.C. office of the Kirklan and Ellis law firm. Jeff is the former General Counsel of the Department of Transportation and former General Counsel and Senior Policy Advisor for the Office of Management and Budget. In addition, he's the current Vice Chair of the ABA Administrative Law Section. And we'll look forward to hearing from all three of these. And Dan, would you get us started?
Thank you, Mark. I'm going to be talking about the class action cases from this past term, and let me begin with a general observation. There is a perception, particularly among many in the media, that this is a pro-business court. I happen to think that's wrong, sort of on 2 levels, one of which is that seems to rest on the idea that justices decide cases based on the identity of the parties or a particular cause with which a party is associated. I just don't think that's true. I think that all justices have particular jurisprudential views and predispositions, which can lead to predictable results in some cases, but not necessarily. I also think, even if you think I'm wrong about that and that I'm being incredibly naive and grossly overestimating the extent to which a justice's personal views color his or her decisions in particular cases, I actually just don't see the evidence of this. In the last several terms, it's far from clear that businesses have been winning even the majority of cases that they've been involved in, much less that they've been winning in appreciably more than the majority of cases. Nevertheless, this view does persist, and the view in particular persists that this court, or at least a majority of it, really hates class actions. And we heard that view expressed a lot in the last few years. In 2011, when the court decided Walmart and Concepcion. We heard it again last term when the court decided follow-on cases to those 2, Comcast and American Express. And I should note, this perception isn't at all limited to the media. Even some members of the court itself have been known to express it. And one memorable expression of that view comes from Justice Kagan's dissent in the American Express case. Justice Kagan is not somebody who is thought to be a firebrand. I think she's generally thought to be, a reasonable, thoughtful person who sees both sides of the issue. But in that dissent, she said, "To a hammer, everything looks like a nail. And to a court bent on diminishing the usefulness of Rule 23, everything looks like a class action ready to be dismantled." Now, that dissent was written almost exactly a year ago But what I would say to you today is that nobody could possibly employ that metaphor in describing what the court did this past term in class action cases. There were three cases with class action issues decided on the merits. The plaintiffs won all three. The combined vote in the three cases was 22-5 for the class. Not a single one of them was decided 5-4. One of them was unanimous. The most important of those cases, which I'll spend most of my time talking about today, the Halliburton decision, which came down on Monday, was a 6-3 decision in which the Chief Justice and Justice Kennedy joined the four members of the court who were perceived correctly as the most liberal members of the court to reject a claim that, if accepted, would effectively have meant that class action securities fraud claims could not be brought. And the man for whom this supposedly pro-business court is named, Chief Justice Roberts, was the author of that opinion. And I guess the last thing I would say about this is that there has been some suggestion among those who advance the view that this is indeed a very pro-business court that it doesn't really do justice to the degree of the pro-business sentiment of this court to just sort of count up the cases and count, business wins and business losses. It's really the most important cases always come out for the business, according to this view. And again, whether or not that's true, and I definitely have my doubts about that, that wasn't the case this term, the Halliburton case, although there was one aspect of it that actually represented a decision in favor of the defendant. By and large, it was a very pro-plaintiff, pro-class action plaintiff decision. And in addition to these three cases that were decided on the merits, there were a couple of class action cases in which the court denied review. These are the Sears and Whirlpool cases, so-called smelly washer cases, which are product liability class actions in which very large and unwieldy classes were certified. Their certification was affirmed by the Sixth and Seventh Circuits. A lot of people thought that those two cases, review would be granted in those two cases, and they would be sort of the third in the trilogy of Walmart, Comcast, and then Sears Whirlpool, where the court decertified classes. That did not happen. So let me just close out my preliminary remarks by saying if this is, in fact, a pro-business court and a court that hates class actions, it had a very funny way of showing it in October term 2013. Let me turn to the three class action cases that were decided on the merits, and I'll try to be as quick as I can in getting through the first two so I can spend most of my time on Halliburton. The first one is a case called Mississippi against AU Optronics. This is a case decided under the Class Action Fairness Act, CAFA for short, which is a litigation reform statute that was enacted in 2005. The basic idea behind it is class action lawyers like to file their cases in state courts, so-called magnet jurisdictions, where the rules either on the face of them or in application are more favorable to class actions, where classes tend to get certified more easily than in most federal courts, where class settlements tend to get approved more easily than in federal court. And the basic remedy that CAFA created was to relax or liberalize the rules for removal so that it's easier for defendants who are sued in certain class actions and mass actions, a term I'll get to in a minute, it's easier for them to remove the case to federal court where it is thought they will have a fairer shot. The issue in the AU Optronics case had to do with so-called parens patriae actions, which are an increasingly common phenomenon where a state or a state's attorney general sues and seeks relief on behalf of a large group of citizens. In this case, the requested relief was restitution. And the question in the case is whether that's a mass action and therefore removable to federal court under CAFA. A mass action is not a class action, but it is essentially a case where there are lots and lots of plaintiffs, and they're seeking to have a joint trial based on common issues of law or fact. CAFA says those cases can be removed. The question was whether a parens patriae suit like this is a mass action. The court said no. It said no unanimously. Justice Sotomayor wrote the opinion. The basic reasoning was, there's a single plaintiff. It's the state, not a mass action, not removable. What are the consequences of this decision? Well, you might think, not really that big a deal. We're not talking about the private class action bar. We're talking about public officials and states. They're probably going to be better behaved. They're politically accountable. They have lots of constituencies, including businesses. And I guess what I would say in response to you, if that's what you're thinking, is that you're pretty much wrong. And I would say that for two different reasons. One is, for those of you who read the newspapers regularly, it won't come as a surprise to learn that there are a lot of very aggressive attorneys general out there who do all sorts of things that one might think are not appropriate things for any litigant to do, much less the chief legal officer of a sovereign state. But perhaps the more worrisome aspect of this is that a lot of states are, at the request of the class action plaintiffs bar, are deputizing private class action lawyers to serve essentially as special assistant attorneys general to prosecute these cases. So as a practical matter, you are getting the very same lawyers bringing and running and litigating these cases as you would if they were more traditional class actions brought on behalf of private parties. And let me just pause to note that Richard Samp of the Washington Legal Foundation has written about this. He's got a very interesting article, which I would commend to all of you if you're interested. The second case is called Chadbourne and Park against Troyes. This case involved the second of two securities litigation reform statutes that were enacted by Congress in the 1990s. The first was the Private Securities Litigation Reform Act, the 1995 statute, which changed procedural and substantive law in federal securities cases to make it harder for private plaintiffs to bring them. The second case, which was enacted 3 years later, is called the Securities Litigation Uniform Standards Act, SLUSA, for those of you who like acronyms, which was enacted 3 years later. And the basic point of SLUSA was the object was to prevent people from getting around the earlier law by filing suits, class actions under state law where the same sort of restrictions wouldn't apply. This case involved the second statute, SLUSA, and what SLUSA says is that plaintiffs can't bring class actions under state law in which the allegation is that the misrepresentation in question was made in connection with a purchase or sale of a covered security. Covered security here means essentially one that's traded on a national exchange. And the issue put generally in the Chadbourne and Park case was how narrowly or broadly the phrase in connection with should be interpreted, which, as many of you know, sort of a recurring issue in securities fraud cases and has been for a long time, although not necessarily in the SLUSA context. And in that case, the plaintiffs alleged that they had purchased uncovered securities, but that the defendants had told them that the uncovered securities were backed by covered securities. So the question is whether that fact pattern constitutes a representation that's made in connection with a covered security. The court said no. So it interpreted this element narrowly, and it allowed the case to go forward in state court. It was a 7-2 decision with Justice Breyer writing. The dissent was by Justice Kennedy, joined by Justice Alito. What are the implications of this case? It's not as clear to me what they're going to be. I guess the one observation I would make is that it will be interesting to see whether what is, on the face of it, a pro-plaintiff decision, which allows class actions based on state law to proceed, ultimately is used in a pro-defendant way. And what I mean by that is that because the federal cause of action, 10b-5, has an in connection with element, if the court is interpreting that narrowly in the SLUSA context to the benefit of plaintiffs, does that mean that lower courts relying on this decision will also interpret it narrowly in the 10b-5 context to the detriment of plaintiffs? And this is actually a concern that was raised in the government's amicus brief in the case filed by the Solicitor General and the SEC. And it probably accounts for the fact that this was one of the extremely rare cases in which a Democratic Solicitor General and a Securities and Exchange Commission headed by a Democratic commissioner and Democratic majority actually supported the defendant in the securities fraud case. So that is something that might bear watching. Okay, let me turn to Halliburton, which is the big securities fraud case. Halliburton is a case involving Section 10b, the Securities Exchange Act of 1934, and Rule 10b-5, which is the SEC rule that implements it. These are the general anti-fraud provisions of the federal securities laws. The court, neither the statute nor the rule itself creates a private right of action. The court has implied one back in the old days when they used to do that all the time. There has been an implied right of action under 10b-5 probably for about half a century now. As with any fraud case, the elements of that cause of action include reliance. Reliance in the fraud context means somebody makes a misstatement to you, it causes you to take some action. In the securities context, that means you buy or sell securities in reliance on the misstatement. There is a decision called Basic versus Levinson, which is a 1988 decision, which held that a plaintiff in a 10b-5 case does not have to prove individualized reliance, but rather there is a presumption of reliance that arises under the so-called fraud on the market theory, about which I'll say more in a moment. Let me just pause to note that Basic was a 4-2 decision. There were only 6 justices participating. It was written by Justice Blackmun. He was joined by Justices Brennan, Marshall, and Stevens. The dissenters were Justices White and O'Connor. The non-participating members of the court were Chief Justice Rehnquist and Justices Scalia and Kennedy. So if you pause to think about that, you will quickly realize that if those 3 justices had participated, the case may very well, and I think I can confidently say likely would have come out differently. During that era, the court is a very common lineup to have those 4 who were in the 4, and those 5 who were the 2 and the 3 non-participating in the 5. O'Connor and White were thought to be, moderate conservatives. Kennedy, Scalia, and Rehnquist more conservative. You'd have to assume that they would have joined the 2, and we might be living in a very different world right now, but we're not. That's been the law for 25 years. One of the justifications for this presumption, this rebuttable presumption of reliance based on the fraud in the market theory, is that if a plaintiff had to prove individualized reliance, you pretty much could not have class actions because individual issues would predominate over common issues, and you couldn't get a class certified. There are 2 basic assumptions that underlie the fraud on the market theory. One is that the market price of shares traded on a well-developed market reflects all publicly available information, including material misstatements, including the material misstatement that serves as the basis for the particular securities fraud suit. The second assumption is that a typical investor buys or sells securities in reliance on the integrity of the price, meaning that the typical buyer or seller assumes that the price is the real, the accurate, the true price. As I say, this is a rebuttable presumption. It can be rebutted in a number of ways, one of which is by showing that the misrepresentation, in fact, did not affect the price of the security. Before Halliburton, everybody agreed that that could be done, that rebuttal could occur at the merit stage of a class action. It was an open question whether that could be done at the class certification stage. The general view is that it could not, and the court addressed that in the decision, and I will get to that in a minute. So this was the law from 1988 to 2013 when the court decided a case called Amgen, which was a class action case, which generated a number of separate opinions. In those separate opinions, 4 justices who wrote or joined them expressed doubt about Basic, about the presumption, about the fraud on the market theory, and suggested that maybe it should be reconsidered. Later that year, Halliburton filed a petition for certiorari, the first question of which was whether Basic should be reconsidered and overruled. A couple of months later, the court granted the petition. Now, this is really an extraordinary thing. There are many cases where there are separate opinions that say things along the lines that I just identified, single justice or more, saying, I have severe doubts about this precedent that the majority is relying on, but nobody's asked us to overrule it here, so I'm joining the majority opinion on the understanding that I have doubts about it. Maybe in an appropriate case we can reconsider it. Sometimes nothing ever happens, and the court never decides to reconsider it. Sometimes the court does, but it takes years. This took months. So there was a real belief, I think, among people who care about this kind of thing that the court very well could overrule BASIC. As we now know, that did not happen. It was a 6-3 decision, and BASIC was reaffirmed. The majority opinion, as I mentioned, was written by the Chief Justice, joined by Kennedy and the 4 more liberal members of the court. And what the majority opinion did is address 3 possible outcomes, 3 claims by the defendants in the case in sort of descending order of breadth or aggressiveness. And the first claim was that BASIC should be overruled. The court rejected that. And if you read the opinion, and certainly if you read it carefully, I think it's not entirely clear whether the court is saying, A, we think BASIC was right, or B, we don't really care whether BASIC was right or not because this is a case about statutory stare decisis. You have to show more than just that the earlier decision was wrong and that showing hasn't been made. Or C, some combination of the two. If you read the dissent, and again, you know, dissents tend to have parade of horribles arguments in them, so you should take this for whatever it's worth. But the dissent characterizes the majority opinion as at least suggesting that BASIC was correctly decided. The second proposed remedy or form of relief was a modification of BASIC, so that plaintiffs would be required to prove that the misrepresentation affected the stock price. The majority said it wasn't going to do that. In effect, that was asking not for all of BASIC to be overruled, but for half of it to be overruled, and the court wasn't inclined to do that either. The last thing the court was asked to do, which it agreed to do, was to hold that the presumption could be rebutted through a showing of no price impact, to use the vernacular of this type of case, on that showing could be made at the class certification stage, and you didn't have to wait to the merit stage. There was a very short concurrence by Justice Ginsburg, joined by Justices Breyer and Sotomayor, though interestingly not by Justice Kagan, which said that allowing defendants to rebut the presumption at the class certification stage and not requiring them to wait until the merit stage should, as the concurrence put it, impose no heavy toll on securities fraud plaintiffs with tenable claims. So one way of reading that decision is Justice Ginsburg and the other 2 who joined it are saying, some of you may be wondering why we'd be going along with this. We're going along with it because we don't really think it's that big a deal, and it's not going to have a material effect on the ability of class action plaintiffs to get classes certified in securities fraud cases. The dissent was written by Justice Thomas, joined by Justice Scalia and Justice Alito, and it made 2 basic points. The first was to challenge the economic assumptions underlying the fraud on the market theory. The second one, which I actually think is more interesting, was not really an economic point, it was a legal point. And it said, you know, what's all this about statutory stare decisis? This right of action is completely made up. It's not in the statute. It's not in the rule. It's judicially created. It's effectively common law. It's not statutory law. We made it up. We can change it if we think it's wrong. And as the dissent put it, in this kind of circumstance, the court should correct its own mistakes. So what are the consequences of this decision? I guess I would say 2 things about it. The first is, you know, there's been a lot of debate. Is this a victory for plaintiffs? Is it a victory for defendants? I guess there are 2 different ways of looking at it. The day before the case was decided, we were living in a BASIC world. The day after it was decided, we're still living in a BASIC world, except there's this modification that helps defendants. So I guess in that sense, it's a victory for defendants. I'm not sure that's the best way to look at it. The fact of the matter is that, as I mentioned before, there was a very real prospect, at least up until the time of the oral argument, that BASIC was going to be overruled, and it wasn't. And I think if you asked any class action lawyer, any plaintiff's lawyer, you know, which would you prefer, that BASIC doesn't survive or that it survives with a slight modification, you know, the question answers itself. The next question is it really going to make a difference, this aspect of the holding that favors defendants? I don't have an answer for that. I don't know that anyone does. I think it's an empirical question. Time will tell. If you ask 5 different people, you'll get 5 different answers. Some people say it will make a huge difference. Some people say it will make no difference at all. I've even read an article that suggests it's actually good for plaintiffs. And I think the theory is that it will force them to establish a price effect at the class certification stage, and it will increase settlement values of cases. Whether that's true or not, I don't know. I think this all remains to be seen. All I would say is that in combination with the denial of certiorari in the smelly washer cases I referred to earlier, these 3 decisions, which are decisions for class action plaintiffs, make it very hard for anybody to claim that this is a court that loves business and hates class actions.
Before I turn it over to you, I just wanted to mention that one of the cases you're going to be talking about is American Broadcasting Companies v. Aereo, which was a case in which WLS filed an amicus brief and enjoyed a good victory today. So look forward to hearing from you about that case and some others.
Thank you, Mark. So yes, my name is Mark Davies. I'm from Orrick, and I focus on intellectual property appeals. And so my docket, my assignment today is to discuss this set of IP cases coming out of the Supreme Court. And I've centered my comments around 3 questions, just so we know where I'm headed. The first is, what can we learn about the Supreme Court's substantive approach to patent law? So a little bit of law. The second question I want to discuss is the Supreme Court's attitude towards the Federal Circuit itself as an institution. You know, how does the Supreme Court perceive the Federal Circuit? And then the third question is the Supreme Court's attitude towards its own set of IP cases. So if I do that right, I'm going to touch on the 6 patent cases from the term and the 2 copyright cases. And I also want to touch on one more case. So I'm going to be moving quite quickly, and I have 20 minutes. So let's start with some laws. What is the Supreme Court's approach to substantive patent law? And I think you can get two big points out of this set of cases. And the first, and I'm going to say this proposition, you're going to think it's a nud-duh, but it's actually quite contested. And that is, to get a patent, you have to invent something. It sounds simple, but that is it is a proposition that had divided the court below. So the case involved a patent on a computer-implemented scheme for using a third party to minimize the risk that one party to a financial transaction won't pay what is owed. So that's a lot of words, but it was basically conceded that the patent itself, there was nothing innovative there. And the argument was, could you nonetheless be eligible for the patent, and were there other parts of the patent statute that would stop a non-inventive patent from going through? Or were you not eligible from the get-go if you didn't have what's called an inventive concept? So writing for 5 judges on the Federal Circuit, Judge Lowery said, show me the genuine human contribution here. If the answer to that is no, then you're not going to get in the door. You're not patent eligible under 101. Another 5 judges, and you'll note there was actually 10 judges sitting at the time, so you got 5, and then you got 5 saying, and they didn't see that, and they went further than that. It said, it is inconceivable to us that the Supreme Court would impose such a requirement on patents. So it's not just that those judges didn't see it in Section 101. They didn't think the Supreme Court conceivably could say it was there. And then Justice Thomas, in the CLS case, unanimously holds patent eligibility asks whether the patent contains an inventive concept. And it didn't seem like a hard case to the Supreme Court. So that's CLS. So to get a patent, you have to invent something. The Supreme Court said it a few times before, and they've said it again. And that is just, it's going to keep coming up. So the second point, substantive point, you can get out of 2 cases. One is called Octane, and one is called Nautilus. And the point here, again, it's quite large, is that patent law is holistic, which is to say they're not going to get very specific with the rules that are going to govern the patent system. So in Octane, it involved the question of when attorney's fees should be awarded in patent cases. The statute just says in exceptional cases. The Federal Circuit had said, strict rule, that you only get fees if the litigation is brought in subjective bad faith and the litigation was objectively baseless. So the Federal Circuit took the statutory phrase exceptional and drew out some quite strict rules. But Justice Sotomayor for the court held that the fees inquiry is more holistic and equitable. A district court should just consider the totality of the circumstances. So the Supreme Court wasn't going with any, it didn't come up with another set of more specific rules. It just said totality of the circumstances. A Nautilus is actually quite similar. The question was the statutory phrase, particularly point out and distinctly claim. It's referred to as the indefiniteness requirement. And Justice Ginsburg said, well, that just means you inform the public with reasonable certainty. So again, it's a very high-level phrase. You have reasonable certainty, totality of the circumstances, and that's really all the Supreme Court is going to give to the intellectual property community out of the patent statutes. They're going to stay quite high level. And so I think from those three cases, you can see where the Supreme Court's going. On the one hand, they want an inventive concept in your patent. They're willing to go that far and insist on that. But beyond that, they're really going to stay quite high level. So that's some law. I think for observers, people who have been around this a while, what's even more interesting is to try to discern the Supreme Court's attitude towards the Federal Circuit. And I should have made this clear, the Federal Circuit reviews all patent cases in the country, so that's why I'm talking about the Federal Circuit. And so here I have 1, 2, 3, 4, 5, I have five data points, and I think you can see where I'm headed. So the first case is Highmark, and the question there was just how much deference an appellate court, would be the Federal Circuit, should give to the fees award of a district court. And the Supreme Court just said, well, you have to defer. It's a factual inquiry. You have to defer. So you got to see, okay, maybe the Federal Circuit, not so popular because they have to defer. On the other hand, that's kind of common that a court of appeals would have to defer to a factual finding. It kind of makes sense. Then in Octane, the fees case that I referred to earlier, you have the Supreme Court referring to the Federal Circuit's test as unduly rigid. So it's not kind, it's not the greatest phrasing, but maybe, okay, you can get them. But then it gets really harsh. So Nautilus, that was the indefinite case. You have the Federal Circuit's phrase test, they'd come up with a phrase called insolubly ambiguous to try to define what was definite. And this is Justice Ginsburg writing, and she says that test falls short of being at least probative of the essential inquiry. So falling short of being at least probative of the essential statutory inquiry, that's not a high bar. And yet Justice Ginsburg, who I don't think is known for being over the top with her rhetoric, is saying you're not there. And then in Medtronic, we have the question, it's a burden of proof question and a declaratory judgment action, but it's just Justice Breyer, quote, simple legal logic resting upon settled case law strongly supports our conclusion, reverse and remand the Federal Circuit. And then you get to Justice Alito in Limelight, who is, I think probably goes a little too far. The question in Limelight was whether someone could be liable for indirect infringement of a patent if no one person was doing all the acts that it requires to infringe the patent. So maybe it gets divided up. So 3 or 4 people are doing the acts that together are patented. Can one person who encourages those people to do that be accused of indirect infringement? And it divided the Federal Circuit. And Justice Alito, in a cursory opinion, really says this. The Federal Circuit's analysis fundamentally misunderstands what it means to infringe a patent. So this is the Federal Circuit, right? This is what they do. Like about half of their docket is patent cases. And this is Justice Alito saying they fundamentally misunderstand what it means to infringe a patent. There's actually, just as a side note, there's actually a mistake in Justice Alito's own opinion of patent law, where he really does misconstrue what the debate is about. So I don't know whether that's going to get fixed, but it's kind of awkward, I think, to have this very harsh rhetoric in an opinion that actually contains a basic mistake. And so then, the third question I'd pose for us is this. What is the Supreme Court's attitude towards its own IP cases? And I raise this question because you often hear about the following dichotomy. Look, the Supreme Court cases are so often unanimous. Every opinion I mentioned so far was unanimous. And yet at the Federal Circuit, they often sit and bank, they divide over these opinions, there's splits. What is going on? Why, on the one hand, is the Federal Circuit grappling with what they see as very hard questions, engage smart people, reaching different results, and then it goes up to the Supreme Court, and you get very short opinions, and they're unanimous. And so that is, I think, a puzzle that it's easy to draw. I I think the easy conclusion for that is to say, well, the Supreme Court, they see it all the same way. The questions are easy, and the Federal Circuit is just blatantly wrong. I think that's a little too simplistic. I actually think probably what's going on is, and this is something that patent lawyers don't like to admit, but I think that what's going on is the Supreme Court doesn't care much about these cases. And that is probably the bottom line. That if you look at these opinions, they're very short, they're very rushed, it seems. They're not, they don't prompt a dissent. And I think that they don't really feel that they had not attracted to these opinions is another way to put it. They don't see them as weighty as maybe some of the industry do. So the longest of all the opinions I mentioned is CLS, that's 17 pages in the slip. It's not very long. Highmark is 5 pages. So they're not putting a lot of bandwidth into the patent cases. And that may be in part due to the substantive point that I was making earlier, that they want to stay high level. But I think it's in part with all the other important cases on the docket. The patent cases are just not yet, or maybe never, rising to the level of getting the full focus some of these other cases do. So that's the patent docket. I think in the copyright context, you do see, I think, a higher level of focus from the Supreme Court. So Petrella is a copyright case. It came out of the Ninth Circuit. The case involved it's a very specific claim to damages for just 3 years of copyright infringement. The facts are really cool. You got a boxing champion LaMotta, you've got Raging Bull's screenplay, but the legal question is very precise, just about whether the equitable doctrine of laches comes into play on this 3-year statutory 3-year claim for damages. And Justice Breyer puts it, it's a little place in copyright law, and yet you get 22 pages of opinion. You get a detailed dissent by Justice Breyer. And so coming at this from the patent perspective, I was just struck by how much attention and focus Petrella got when all these other cases that I mentioned really got very little time. So Arrow came down this morning. The technology here is complex, but it basically is a way for me to sit at home and watch a local broadcast TV show without paying anybody to do it, or without paying broadcasters to do it. And it feels like, well, hey, wait a second, how can that be okay? But as Justice Scalia points out in the dissent, what's really going on here is there's a legal loophole that Congress really didn't envision when they wrote the Copyright Act, this type of scheme. And sort of how do you reconcile the fact that it feels kind of odd, even to the dissenting judges. It felt unfair on the one hand, but on the other hand, the statute was written in the world of cable operators, not in the world of the internet and the technology that we have today. And as in the decision that came down today, Justice Breyer sort of starts with congressional purpose. And I think whenever you see a lawyer starting with congressional purpose, you kind of think in the text may not be with you. And when you see Justice Scalia in dissent talking a lot about the text, you think maybe he has a point. Justice Breyer, I think, was very concerned about the loophole, and Justice Scalia was making the point that, well, that really should be for Congress to solve. And I think I don't want to take sides in which is right and which is wrong, but I do think it's noticeable that type of problem is going to come up a lot. The statutes are written for one age, different problems, different technology later. How do you resolve that? Do you say, well, let's stick to the words, let's go to Congress, or do you try to divine some purpose? And if so, how do you play it up? And so the last case I want to draw your attention to, and it's actually not an IP case, but it came down this morning, and I think this is one that's going to should rightly get a lot of attention for a lot of different reasons. And so because neither Dan or Jeff are going to mention it, I wanted to just touch base on it. So it's Riley versus California, and it's the question of whether the police, having arrested somebody, can go through the cell phone, or whether they have to get a warrant to do so. So in one of the cases, they flipped through the phone, they saw a picture, and that helped them prove that the guy was in the Bloods, in the gang. In another, flip phone calls kept coming through, and they managed to find the home address, and they went and they found the cocaine at the home address. And so the court today says you need a warrant to do that, police. You can't go through and just search someone's cell phone. And it's not just the holding, which I think is really important, but the way that Justice Roberts, writing for the court, with I think Alito concurring, he does a really nice job of describing how important cell phones are today. Not just in a functional way, but he has a really humorous line. Let me try to find it, where he says, cell phones are now such a pervasive and insistent part of daily life that the proverbial visitor from Mars might conclude they were an important feature of human anatomy, which I love, and it does match how people around me live. But beyond the humor, he talks about how having the immense storage capacity of today's cell phone. It used to be you find somebody's wallet, you got a couple pictures, fine. But now you can go through somebody's cell phone and really get a very detailed sense of who they are, tons of information that maybe they don't want other people to see. And so, so both because of the importance of the holding itself, but also because of the sensitivity to how technology is moving into our lives and how that requires rethinking of legal rules is why I wanted to bring that one to your attention. And with that, I'll sit down.
Jeff, would you like to finish up here?
Yes.
All right, well, good afternoon. I'm Jeff Rosen. I have the privilege, pleased to address today the Supreme Court's decisions that involve government regulatory agencies in the economy, of which there were a handful this term. Quickly pass on, there were two preemption cases. There seemed to be some every term. They came out opposite ways. One found preemption, one didn't. That's a big, important subject. And the two cases are Northwest versus Ginsburg and CTS versus Waldberg. But because that involves lots of cases that weren't this term, because I don't think these two cases in particular are landmarks of any sort, I wanted to instead focus on three cases that the court decided this term that involve how much latitude or deference agencies get. And I'll preview. The bottom line is that agencies that overreach in a major way can't expect a free pass. But that might not have been obvious until the term was over. So the three cases I want to talk about are EPA versus EMA Homer City, Scialaba versus Cuellar de Osorio, and UARG versus EPA. There is a fourth important case involving federal agencies, and that's the Recess Appointments Clause case, the NLRB versus Noel Canning. I'd hoped to talk about that, but it hasn't been decided. So it's one of four cases that are left on the court's docket for this term, and it'll come out either tomorrow or Monday. That one may ultimately prove to be the most important one, because it involves recess appointments if either the Republicans take the Senate next year, or over the long haul if there are disputes between presidents and senates in the future. But as I say, I don't think it makes a lot of sense to get into that one in too much detail because we don't know how it's coming out. So I'm going to focus on the three I mentioned. Of these three, let me start with the Homer City and Scialaba cases first. They involve the Environmental Protection Agency, EPA, and the Bureau of Immigration Appeals, the BIA. And these were written by Justice Ginsburg and Justice Kagan, respectively, which perhaps will tell you something about the amount of deference the agencies get. 2 weeks ago, after these cases were out, but the UARG versus EPA case was not, I might have said these presaged a court starting to take up Chevron deference on steroids. These are very robust applications of the Chevron deference doctrine in situations where it was not so clear beforehand that that kind of deference would be afforded to the agencies. These two opinions seem to provide wide latitude for agencies in a couple of different ways. Scialaba, the immigration case, involved a statutory construction of provisions about the priority and timing of where certain aliens fit into the immigration queue. I won't get into the weeds, but the statute involved arguably textual provisions that were at odds. Now, some might think that that's classically what courts do, is resolve textual conflicts. But the court said that having this conflict created an ambiguity. And there being an ambiguity, then the agency could do an interpretation, decide in its discretion what policy to pursue, and receive deference for that. And in Justice Kagan's phrase, she said, this is, quote, the kind of case Chevron was built for, close quote. Maybe she thought that was obvious, but it was a 5-4 decision. And one with a somewhat unusual alignment, in that you had Justice Kagan and Justice Ginsburg aligned with Justices Kennedy, Scalia, and the Chief Justice Roberts in the majority. And that's an unusual configuration, what sometimes perceived as 2 of the liberal justices and 3 of the conservative justices together for a 5-4 majority, saying agency is going to get the latitude to decide what to do when the statute gives conflicting commands. Then we get to Homer City. This is a case that involved EPA's transport rule, which is the successor to the Bush-era CAR, C-A-R rule. They both involved issues of pollution from one state that migrates to another state, and what restrictions EPA would require for cross-state pollution. And the court found the phrase contribute significantly to cross-state or interstate pollution to be ambiguous. But it not only allowed EPA to say what the statute means, it allowed it to devise a very complex multi-part test and to use a factor, cost, that isn't even mentioned in the statute as a part of the formula for allocating what each state's burden would be in this interstate pollution situation. And now, without commenting on whether the test is a good policy or bad policy, what was significant here was the D.C. Circuit had said it had gone too far, that it had used factors not even mentioned in the statute. It had done more than just come up with a reasonable interpretation. It had gone beyond what the statute would permit. Supreme Court reversed, this time with 6 justices, and Justices Kennedy and Chief Justice Roberts, as well as 4 justices from the more liberal wing, and gave more latitude to EPA. So the story of those 2 cases is one of very robust deference to agencies, both as to when a statute can be interpreted by the agency and get deference to its interpretation, and as to how far it can go in filling the gap. But, as I hope I previewed, that wasn't the full story of the term, as there was a 3rd decision, UARG versus EPA, that proved to be a harsh rebuke of agency overreach. So any message of agency latitude was tempered in a big way in UARG versus EPA, which only came down 2 days ago on Monday. And that was a case, I should mention, that had 6 cert petitions granted and combined. I was counsel to one of the petitioners, I should probably say, and I should also commend that Washington Legal Foundation submitted an amicus brief in the case on the side of the petitioners who prevailed. Case was sharply critical of EPA's implementation of the Clean Air Act and of the executive branch's overreach with regard to the statute. So let me summarize the significance of this in a couple of ways. As to EPA, this ruling is most significant in its holding that the regulation, which concerned greenhouse gases, that the regulation of previously unregulated stationary sources of greenhouse gases was neither compelled nor allowed under the relevant part of the Clean Air Act. So that refuted EPA's statutory construction and disallowed its policy choice as being not reasonable or within the parameters of discretion. The upshot is that ruling protects millions of entities around our country and throughout our economy. Small businesses, hospitals, schools, churches, and others are protected from being regulated by EPA as stationary sources under the PSD and Title V programs. It's also significant in that the court plainly restricted the application of its earlier 2007 Mass versus EPA ruling. I'll say more about that in a minute. More broadly, for agencies and lawyers more generally, the case is significant in that the court, once again, restricted an agency's self-aggrandizing claim of authority over a big part of the economy, somewhat as it had done with regard, for example, when the FDA sought to regulate tobacco and was invalidated under Brown versus Williamson back in 2000. And it's significant to agencies that the court invalidated 2 agency rules in the case, even under the very deferential framework of Chevron versus NRDC. So let me elaborate on some of these points. Let's first say, what had EPA done? There were really 3 rules that were in play, but only 2 that were before the Supreme Court. One was a background. The first rule that was the background was EPA had issued after the Massachusetts versus the EPA decision, so-called auto rule or tailpipe rule, regulating the fuel economy of vehicles and thereby the greenhouse gas emissions from motor vehicles. That rule had been challenged earlier, but was not in this case. But what was at issue in this case, the first of the 2 rules, was the so-called triggering rule, by which EPA had said that once it regulates under Title II of the statute, the motor vehicles, it is automatically required to regulate stationary sources under the PSD program in Title I and Title V of the statute. So that's what's called triggering, is that once it's a regulated substance anywhere under a statute, it's triggered for stationary sources. And since that would encompass huge numbers of new entities that were not previously regulated by EPA, they were going to do what they called the tailoring rule, which was to start with big entities like power plants, for example, and then phase in regulation of greenhouse gases as to others in stages. So the triggering rule and the tailoring rule. And the tailoring rule would alleviate the fact that the statute had set very low thresholds for what emissions counted with regards to at least conventional pollutants. So the triggering rule and the tailoring rule were challenged in the D.C. Circuit, and in a 3-0 decision, the D.C. Circuit ruled for EPA, in part on the premise that the Supreme Court's Massachusetts versus EPA decision dictated the result. This was challenged by parties in every sector of the economy. I think there were about 10 cert petitions filed, but by combinations of groups. And the Supreme Court took 6 of them. And as 4 cabinet departments had warned, these 2 rules, the triggering rule and the tailoring rule, would have made EPA into a de facto national zoning authority if EPA's interpretation prevailed. So what did the Supreme Court do? There were 2 parts to its decision. The first part dealt with EPA's claim that it had no choice but to regulate these stationary sources, that this was legally compelled by the statute and by the Supreme Court's decision in Mass versus EPA. But as a backup or fallback, the agency said that this was also the agency's own reasoned policy choice that should be entitled to Chevron deference. The Supreme Court rejected both contentions under both prongs of Chevron, said they'd read the statute wrong, it said that they didn't have the discretion to do what they did, and it effectively struck down both the triggering rule and the tailoring rule. So that's the first part of the decision. The second part, at the same time, dealt with what the court called anyway sources, meaning parties that were already required to get PSD permits because they are large emitters of conventional pollutants, ozone, mercury, and the like. What the court did is to those, it said, well, to get those permits, there's something called BACT, Best Available Control Technology, and that with regard to the BACT requirements, EPA could make the discretionary policy choice to include greenhouse gas in the BACT assessments. I'll mention in a minute, the court also put some important limits even on that. But that's the two parts of the case. So a couple of quick observations. One is, as I said, the court plainly cut back on Massachusetts versus EPA. Court says at page 14, just to quote, Massachusetts does not strip EPA of authority to exclude greenhouse gases from the class of regulable air pollutants under other parts of the Act where their inclusion would be inconsistent with the statutory scheme. And Justice Breyer, in dissent, protests, quote, the court's decision to read greenhouse gases out of the PSD program drains the Act of its flexibility and chips away at our decision in Massachusetts. And I think it's plainly correct. And for those who question, well, does that matter? In the D.C. Circuit oral argument in the arguments about the triggering rule and the tailoring rule, Judge Sentel, you can see in the transcript, repeatedly said, aren't our hands tied by Mass versus EPA? And the Supreme Court's answer is no. Second observation, my larger theme, Chevron deference, totally rejected under both prongs. We don't see this that often, where the agency loses under both prongs of Chevron, that they made a statutory, they made a claim that the statute was clear and unambiguous, that Congress had spoken directly to the issue, and the court said, no, that's wrong. And the agency said, and in any event, this is our policy discretion, we can fill this gap. And the court said, you might have been able to, but not the way you did. What you did was completely inconsistent with the law, with the statute, and it's not susceptible to that interpretation. You have to be reasonable, but you were not. And the reason the court said the agency was not reasonable was itself of some interest, because there were at least a couple of reasons that I'll flag. One is that it was conceitedly economically, quote, calamitous consequences, close quote, of interpreting the Act the way EPA had, which was to claim the authority to regulate up to 6 million emitters of greenhouse gases around the United States in a way inconsistent with the statute. And the second thing that's interesting, I alluded to Brown versus Williamson, the tobacco regulation case that the FDA's authority was rejected back in 2000. Court invoked that case to say that EPA's interpretation was unreasonable because of this transformative expansion of its authority. And I think that's an important reinvigoration of Brown and Williamson because Brown and Williamson had been argued by the losing side in Massachusetts versus EPA without success. And now the court's accepting it again, and that's a reinvigoration of some importance. So apart from those couple of observations, something else I wanted to comment on. I have heard some spin from government agencies and their allies that EPA won despite losing on the triggering and tailoring rules. So let me just read 2 or 3 quotes from the case and let you decide if you think this is what the government was hoping for from the Supreme Court. First, after the Supreme Court says that EPA was, quote, laying claim to extravagant statutory power over the national economy, close quote, the court says on page 19 and 20, quote, since, as we hold above, the statute does not compel EPA's interpretation, it would be patently unreasonable, not to say outrageous, for EPA to insist on seizing expansive power that it admits the statute is not designed to grant, close quote. Quote, in the tailoring rule, EPA asserts newfound authority to regulate millions of small sources, including retail stores, offices, apartment buildings, shopping centers, schools, and churches, and to decide on an ongoing basis and without regard for the thresholds described by Congress how many of those to regulate. We are not willing to stand on the dock and wave goodbye as EPA embarks on this multi-year voyage of discovery. We reaffirm the core administrative law principle that an agency may not rewrite clear statutory terms to suit its own sense of how the statute should operate. Quote, were we to recognize the authority claimed by EPA in the tailoring rule, we would deal a severe blow to the Constitution's separations of powers. Under our system of government, Congress makes laws, and the President faithfully executes them. quote, "We are aware of no principle of administrative law that would allow an agency to rewrite a clear statutory term, and we shudder to contemplate the effect that such a principle would have on democratic governance." I submit that that is not what EPA was urging the court to rule. For a nice summary of some of what the court actually said and did, yesterday's Wall Street Journal had a good editorial dealing with this issue of the spin, and I commend it being read. But what about the claim, the best available control technology part, because people will be interested in that part with the so-called anyway sources, like power plants that already have to obtain PSD permits. Even as to those, assertions about EPA carte blanche are way off the mark. In the near term, it's unclear how much, if any, of EPA's regulatory program survives Monday's decision. A couple of quick observations. One, court left open the ability to challenge the implementation of the BACT rules. They said, quote, "Our narrow holding is that nothing in the statute categorically prohibits EPA from interpreting the BACT provision to apply to greenhouse gases." So all they're saying there is they're not saying that the statute categorically prohibits that with regard to any way sources. Second, court noted a series of limitations on BACT that will have to play out over time. Examples, quote, "It has long been held that BACT cannot be used to order a fundamental redesign of a facility," close quote. There are others, that BACT may not be used to require reductions in a facility's demand for energy from the electric grid. BACT should not require every conceivable change that could result in minor improvements in energy efficiency. So this is going to have to play out going forward, but it's far from a carte blanche. But perhaps most significantly with regard to the BACT, the best available control technology part for anyway sources, is what the court said is that some EPA regulation of greenhouse gases in that context is permissible, not that it is required. So what does that mean? That whatever EPA decides to do may be temporary, depending on the next administration that takes office in 2017. A new administration might simply revoke any GHG requirements for PSD permits, since EPA itself has said that its regulations have virtually no actual impact on reducing global warming temperatures. We'll have to wait and see. So all in all, the UARG versus EPA case marks an important decision, not only in restricting EPA's overreach with regard to its regulations, but it's also an important case as one that tells agencies that Chevron deference will not always protect their rules and actions, and it cautions the executive branch about usurpations of powers over the economy that were not delegated by Congress. In that regard, as I alluded to earlier, the Noel Canning recess appointments case will be an interesting one to see what it says about executive branch authority. So before I wrap up, let me just flag for people two recent grants of certiorari regarding agencies and administrative law that I think bear some real watching for next term. Both are cases where the government lost below, and the Solicitor General asked the Supreme Court to hear the case, and the Supreme Court has now agreed to hear both of these. First is Department of Transportation against the American Association of Railroads. For people who like administrative law, it's a fascinating situation because it's about the non-delegation doctrine. Some of you may remember that as being a big issue in the battles over the New Deal in the 1930s. So it's back. It's periodically been raised, but it's back. The issue in the case is whether the Rail Act of 2008 is an unconstitutional delegation of legislative power to a private entity, in this instance, Amtrak. So we'll stay tuned to that one. The second one, Perez versus Mortgage Bankers, addresses the question of whether an agency must use notice and comment rulemaking to change a definitive interpretation of its own rules. So if they issue a rule, they issue an interpretation, can they change the interpretation without going through notice and comment process under the Administrative Procedure Act? The particular rule in question is whether interpretation involves the application of a rule, whether mortgage loan officers are subject to Labor Department regulations on overtime and minimum wage requirements. It's a situation where Labor Department changed its interpretation, and the D.C. Circuit said they needed to have used notice and comment rulemaking procedures. It's important in the situation as to the regulations at issue, but it's a broad application as to when must an agency use notice and comment process to change its interpretations. Again, we'll stay tuned because both of those are big administrative law questions for the next term. But at least this term, the three decisions we saw say sometimes there's latitude to interpret the statute, to fill the gaps, but agencies that overreach, the Supreme Court's watching. Thanks.
Thanks, Jeff. I have a couple of questions, but before I ask them, I wanted to see if any of our panelists had a question for any of the other panelists based on the remarks that were made. If not, then I will invoke the moderator's privilege and start with a question for Mark. If the Supreme Court doesn't care about the patent cases, why does it keep granting cert in these cases, do you think?
It's a great question, and I'm puzzling over that. I think it doesn't care. They care about them, but I think there's a few things going on. One is they've always taken a few, and law of small numbers being what it is, a few more all of a sudden becomes 6 instead of 3. So I don't know how much to read into it. There's one. Second, there's definitely in the last set of years been an influx of appellate lawyers into the patent space. And so people, out of the SG's office and whoever, who know what the Supreme Court wants in the cert petition. So I think some set of, they're seeing more of the type of thing they expect to see in cert petitions. So I think that's going on. And I think the court is aware of, there's many more amicus briefs in these cases than there used to be, because the tech industry will flood on cases. So there's some, so I think that the real world is, they are more important now than they used to be. And so it's not shocking they're taking more. But I think when they sit down and they have this EPA and they have securities, it doesn't seem to yet rise to the level of the chief wanting to write on it, for example.
But perhaps a corollary of that is, if you look at the justices' own backgrounds, you have Justices Kagan and Chief Justice Roberts worked in the SG's office and worked in the White House and were appellate practitioners. So they know something about agencies and administrative law, and they know something about very substantive subjects that they worked on but weren't IP litigators. And if you look at the court, you could probably do the same thing as to what were their backgrounds. There was employment or civil rights or prosecutors and so on. But try to think who spent their career doing IP.
Just set up your some trademark. But you're absolutely right. None of them are engineers, for example, or computer programmers.
Dan, you mentioned the Halliburton, talked about the Halliburton case in some detail, and that's another case in which the Washington Legal Foundation had an amicus brief, and actually the court ended up essentially doing what WLF had asked for as the backup alternative in the brief that we submitted. And I know you said that time will tell, it's an empirical question, and you asked 5 different people, you got 5 different answers, but I'd like to ask you, do you think the settlement value of cases will go down even if the pre-certification defense costs go up? I mean, at the end of your remarks, you sort of implied the opposite of that, but one possibility would be that the settlement value of these cases could go down if the economic packages that the plans put together aren't very persuasive or robust at the class certification stage.
Right. I guess I will stick with my general answer that it's too soon to tell. Look, if the defendants will now be able to do something at the class certification stage that they weren't previously, most actually, I don't know whether this is true as an empirical matter. I would say that many class actions either settle or don't settle after the class certification determination is made. So if a class is certified, appeals are exhausted, and it remains certified, they will invariably settle. If it's not certified and appeals are exhausted and it remains not certified, it will settle for pittance or it will be dismissed because it's just an individual action. So if this, it's not clear to me how this new rule or this new tool that defense counsel in class action cases will be able to use will affect settlement values, because it's happening at the class certification stage, and if it works, there's going to be a nominal settlement, and if it doesn't work, I guess you could see the argument that it will actually increase the settlement value, because plaintiff's counsel will be able to say, in the old days, you might have been able to say that you would yet prevail on that argument at the merit stage, but now that you have to assert it at the class certification stage, and you've lost, we know you're not going to prevail on it, so we have a much better chance of winning. That's my sort of preliminary view.
So if class certifications are denied more frequently as a result of this, that would be a positive, but if they're not, then it's at best a wash and perhaps a negative.
Right, exactly. I mean, it will be, if it's helpful to defendants, it will be helpful because they'll be able to defeat class certification more. It's not clear to me that it will be helpful because they'll have to pay lower amounts in settlements.
Just chime in for a second. I think the Supreme Court really struggles with trying to predict things like that, because it is not something that the Supreme Court is set up to do. I mean, if Congress was doing it, they could have experts come in, you could do studies. I mean, this executive branch, legislative branch have systems for it. The Supreme Court really is kind of hamstrung in trying to figure out what's really going on out there. And so that's where the amicus briefs do take on, I think, a really important role in providing that type of real-world information. And so in the Riley case that I mentioned, Justice Roberts cites, leans quite heavily on 3 or 4 different amicus briefs to make real-world points, like we also said, cell phones and what's on the cell phone. I mean, that's not, he's pulling that out of amicus briefs.
Right. Other questions from the audience?
Mr. Davies, in regard to the Federal Circuit, two questions. First, somewhat facetious. Isn't the honorable thing for them to do to all quit? Or secondly, does the background of a prospective Federal Circuit nominee just inexorably tilt the Federal Circuit toward the interests of patent holders rather than the opposite? Is it regulatorily captured from the get-go?
No, I don't think it's regulatorily captured at all. And in fact, if you look at the newer judges, I think they are more in keeping with what the Supreme Court is expecting. Judges Rainey and Wallach, I think, weren't right in all the cases I mentioned, but they were right in most of them. Right being in the sense of following where the Supreme Court went up. Judge Toronto, who's new, very experienced, fabulous generalist attorney. Ray Chen is from the patent office, it's true, but so he has that patent baggage, but but that traditional sort of patent approach. But Judge Hughes is trade, Judge Rayner's trade. So I don't think it's by background. I mean, it's an unusual court of appeals. It is. It's the only one that has this sort of, informally anyway, this substantive docket. But the D.C. Circuit sees a ton of agency cases. It attracts people who are interested in agency law, and it doesn't run into this type of result. So, no, I'm optimistic that over time that it'll line up. I don't think it's an inevitable part of the system.
Other questions? Rich?
I have a question for Dan. Certainly, a lot of people cheered the Walmart decision a couple of years ago for imposing restrictions on class actions that made sure that in the effort to make the action efficient, the rights of defendants were not shortchanged, and that defendants would have a right to raise every possible individual issue, which would in turn sometimes prevent class certification. There have been complaints that these same sort of problems exist in state court class actions. Obviously, Walmart only applied Rule 23 to federal class actions, and I'm wondering if it's realistic. We've seen a number of cert petitions filed and denied in the last couple of years by defendants arguing that due process required the Walmart rules to be applied in state court class actions. Is there any future in that sort of argument?
I mean, I think there are due process limitations that can plausibly be argued. Sort of the extreme version that basically you have to apply Rule 23 as it's applied in federal court. In state courts, that seems unlikely to persuade many people. Seems unlikely to persuade the Supreme Court. But I mean, you do see petitions for that, and your petitions on those issues, and you're absolutely right that they haven't been terribly successful. I think in part, the ones I'm familiar with anyway, they probably haven't been successful, not necessarily because a majority of the court just thought there was nothing to the argument, but probably because they tend to be quite fact-specific. And, you know, in the absence of a circuit split that you can point to, a plausible circuit split, your chances of getting a petition granted are extremely low. So, for example, you know, there are all those, the Engle cases from Florida, the tobacco cases, which involve huge amounts of money. And there have been various decisions from Florida courts, the 11th Circuit, and multiple attempts by different tobacco companies to get the court to take the case. There's absolutely no interest in doing it, and there are very good lawyers writing those petitions. And I mean, if I had to guess, I would say that the reason is that the court just used them as sort of, you know, sui generis cases, and it's not interested in taking sui generis cases. If a legitimate circuit split could develop on, you know, constitutional limitations on class action procedures in state court, I'm confident that the court would be much more interested in that issue.
Mark, one of the cases that you didn't talk about was the Palm Wonderful, the Coca-Cola case. Do you have any thoughts on that?
I did 8 or 9.
Okay, yeah, I know. You admirably covered a huge scope in a short
sorry,
period of time.
I'm not,
okay.
I've got nothing on that one.
Fair enough. Well, Dan, you asked a question or made some comments in your remarks about the reputation of the court as being business friendly, and I'd like to throw that question to Jeff and to Mark. Is that trend, if it was ever true, is it holding this year, considering decisions like, well, you mentioned Sears v. Butler, but I would also mention Mingo Logan Coal v. EPA, where cert was denied, ExxonMobil v. City of New York, where cert was denied, Medtronic v. Stengel, where cert was denied. These were all important cases to the business community that the court seemed to take no interest in. Do you have thoughts, Jeff, on Dan's thesis that maybe this isn't such a business-friendly court after all?
I never thought that charge was true. I never thought that was a valid legal point. I always thought that was a political argument, and still do, that people who want to overturn a Supreme Court decision, and, you know, a number do get overturned by Congress from time to time. Statute of limitations in an employment discrimination case was overturned in the Lilly Ledbetter Act, for example. When people are trying to generate momentum for legislative arguments, they say, well, we've got to do this because the Supreme Court is tilted one way or another. And I just treated this as a political argument that I didn't think was fair or accurate with regard to the court in the past or present. I don't think it's pro-business or anti-business either way, really. I think you can point to cases, as we heard today, that come out some one way, some the other way. It's not, I don't really think the court's deciding based on the identity of the parties.
So really, in the IP context, the way that dynamic gets played out, I think, is between the trolls and then the big companies. So a patent troll, it's pejorative, it's the more non-practicing entity. But for the uninitiated, the idea is if I own a patent and all I do is go out and sue people, I could be considered a troll because I'm not making a product and trying to protect it with my patent. I just have a patent and I'm suing people. And so big companies don't like that, and a lot of plaintiffs' lawyers have patents, and so that's one of these big tussles is between the non-practicing entities and the big corporations. And it's getting muddy as corporations start buying patents, and it gets muddy. But just if that's the dynamic, which I think matches sort of what you're asking about, what I think it's interesting what's happening here. You can line up a lot of these cases and say that they're bad for trolls. So the fee shifting one, for example, if I sue you on a meritless patent, now I'm risking having to pay the attorney's fees. The indefiniteness requirement, for example, if I have a lousy patent but it's got some vague language, that hurts me. You can line up a few of them that way. People have done that, and certainly there were amicus briefs pushing those points. We did one for Apple, but none of that's in the opinions. And so I don't know whether it's because that's not the way the court's approaching it, or they don't want to write it that way. I think I'm where the panel is. That's just not a dynamic that they really buy into. I think they think if you have a valid patent, you should be able to enforce it. If you got a lousy patent, you shouldn't. And whether I'm sitting on a beach or whether I'm building a robot, I don't think they think really matters from a legal perspective. So I think it's very much out there in the politics and in the talk and in the chatter. But at the end, I haven't seen it really driving the opinion.
Okay. Glenn, do we have any questions from the online audience? Okay. Any other questions? Maybe this will be a final question then. There was a case, and I think, if memory serves, that we covered this at our midterm review, and so it's one of the cases from earlier in the year. But I think it's an important case, and potentially even a landmark case going forward. It's the Daimler v. Baumann decision, which changed the scope of general jurisdiction going forward, and at least under the broadest interpretations that Rich Stamp and others here at the Washington Legal Foundation have been pushing, suggests that going forward, corporations can only be sued in their state of incorporation and in their principal place of business under general jurisdiction theories. If the court, in fact, means in the earlier Goodyear decision and the Daimler decision to have that broadest, I guess I should say that narrowest scope for general jurisdiction going forward, is that going to have maybe a bigger impact on class action cases than even some of the CAFA cases you were talking about, Dan, or some of the other civil justice reforms that companies have been pushing for?
Yeah, it's an excellent question, and I don't really have any well-developed views on that, other to agree with you that it's an important decision, and it's an area, personal jurisdiction is an area the court seems to be interested in, and it's recently anyway probably one of the few areas where businesses tend to do consistently well.
Any other closing thoughts?
I do. Let me just mention one case. I'm involved with it, so I'll try to be neutral. There's a case called Oracle versus Google, which is a copyright case turning on who wrote Java and whether much of it was put into Android. And the Federal Circuit wrote a panel opinion on that one. Google did not go en banc, but the thinking is that we'll go for cert. That's just a great, really interesting case to follow. So I definitely would urge people to follow that.
Any final thoughts, Jeff?
No, not really. I mean, I had already talked about the 2 cert grants for next term that I think are important, that invite you in the next update to take a look at, but appreciate everybody's comments. I think it's been an illuminating discussion.
Terrific. Well, thank you, all three of you, for being with us today, and thank you for joining us online for this year's Supreme Court review.